Hey everyone, it's time to get talking about GDPR again. It's Rob Beeler calling you in from the Beeler.Tech studios, if you will. And today I've got Ari Levenfeld from Sizmek, the Chief Privacy Officer there, and we're going to talk a little bit about really what's going on. You know, now that May 25th has passed, and make some recommendations. Definitely open to questions. There's a chat box for that, but. Probably going to hold most of those things until the end, but yeah. So let's dig in. May 25th, right? Big day for everyone. I actually happened to be in Europe at the time. It was kind of cool to actually do the final countdown. Midnight strikes. Europe did not go up in flames. Really, normal people didn't seem to react. Everyone I know in ad tech did. But May 25th has come and gone, and I'm really kind of curious as to some of what you saw happen around that time, and what you've seen since then, what the implications have been.
Yeah, I mean, I also was worried that I was going to disappear into a cloud of smoke when midnight struck in Europe on the 25th, but I did not. What we did see, and so my company operates on the buy side, so we're listening to a lot of signals and then serving ads on the buy side, is that there was a big drop in the number of bid requests or calls for ads to be served right away on May 25th, and then it spiked back up again, and it sort of continued to look like an EKG monitor for a few days after that, and now it seems to be stabilizing quite a bit, which is interesting.
Yeah.
We definitely also noticed that there was a difference between signals that we were getting from Google related products. So anybody using DFP or going through AdX, for example, and everybody else. So that was interesting as well.
Yeah, and I definitely was there, right on the spot, and it was fun to watch people look at their phones and see who was actually on in Europe anymore and whatever. And then again, you saw people try to work to rectify that. So, I mean, in some way, this is the new normal, right? I mean, it is a daily thing to think about compliance, right? It's a daily thing to think about consent with your users. So, I think this is something for us to kind of watch. But the scramble, if you will, is kind of over, right? Now I think it's, yeah, go ahead.
I was going to say, for the most part, it is, and this might not be something that for what we're talking about today or this particular audience will care about as much. But I noticed that there still seems to be a scramble on the legal side of people suddenly realizing, oh shoot, I need to have this special contract called the data processing agreement in place. Right. So I'm seeing a lot of those go through. But yeah, I think in terms of the operational stuff people have set up, they've either done it or they haven't at this point.
Well, and to the people who've done it, that's the one thing that I'm curious about has been, so it's not like a checkbox, it's over. People are obviously waiting and seeing, are people, are you at least having some conversation with people going like, I did everything I could to get through May 25th. Now it's time to actually start to think through what the true implications of this are and what's involved.
Yeah, for sure. I mean, it's not as though people who have made a decision leading up to May 25th can't change what they've done, or if they decided to go in a particular direction that they don't think is working for them, they can't change. It just depends. It depends on where you sit, I think, in the digital world. So I know that a lot of publishers, for example, that we talk to, are continuing to try and figure out, does it make sense to use either the consent management provider that they've gone with? Does it continue to make sense to work with Google's solution, which many of them obviously have, or not? And nothing is necessarily set in stone, as I mentioned. So I think that now's the chance for everybody to take a breath and actually say, okay, what's working and what is affecting the amount of demand that I have if I'm on the publisher side, and what can I do to change that?
I know you're a big proponent of the IAB EU framework. Can you talk about why you're leaning in that particular direction?
Yeah, I mean, I think it's something that's been worked on for about a year and a half now, from when IAB and some member companies started on it to now. And the reason why I think it's valuable is that it's a standard. It's a standard. I know they don't like to use the word solution, but for lack of a better word, um, that people on both sides of the fence, the buy side and the sell side, can use to be able to continue to legally generate demand for their inventory and then respond to that demand. And as you know, things in programmatic have to work in a sort of universal way. Everybody cannot come up with their own version of what a consent signal or what a transparency signal looks like. There has to be a common language that everybody's speaking with, and I think that's really the most valuable thing about the IB framework is that it's a standard.
Right. Something that we can all gravitate, just one less thing that could potentially to trip things up. But a lot of people have, and even with the IAB EU framework, a lot of people are doing it well in your perspective wrong, right? Or you're seeing people not necessarily working toward getting consent in the proper way. And I think that's a particular interest to this audience is to some of the implementation things that you've seen. Where are some things that people perhaps are not thinking through?
Yeah, I mean, I think that it's important to remember that at its core, the framework is designed to comply with the law. That's the big difference between May 24th world and May 26th world.
Right.
And remember that there are actually two laws that you're supposed to comply with now. There's the GDPR that's getting all of the media attention, and that means that to comply with the GDPR in this case means that you are establishing a legal way to process data for yourself as a publisher, and then for technology companies to work with. And then secondly, there's still this law that in Europe that's been around for a decade called the e-privacy directive. That did not go away on May 25th. It's still in effect. And so that's the one that's responsible for the cookie banners that you see on the bottom of web pages for us Americans when we go to Europe, or people in Europe that you see all the time. That e-privacy directive requires that you obtain consent to access a user's device. And both of those things need to exist on the page and be transmitted back to the technology companies that a publisher works with. What I've seen in many cases is that we are not there. There's not an actual message to the user who's visiting a publisher page that says, "I need consent to access your device." Can you either click yes, or by proceeding to the site, you agree that we do have consent, and then here are the processing purposes for GDPR. Do I have consent for that? So I'm not seeing that appear on a lot of publisher pages. Instead, they're using either the IAB framework or Google's framework as simply a whitelist, and they're choosing which technology companies to send the signal to, and that just creating a whitelist of who, as a publisher, you prefer to work with is not enough to comply. That's probably the biggest area of potential signal noise that we're noticing.
So what you're saying is, and again, correct me if I've got this wrong, is people have implemented a solution that is favoring the tech companies they want and want to share data with, punishing the ones that they don't, right? If you will, and actually really not pulling in what the actual purpose is of getting the consent from the user to have kind of control over how those particular pieces. Is that a way? Am I framing that correctly?
Yeah, I think you framed that exactly right, and that goes back to some of the discussions that publishers have had with the technology community leading up to the GDPR. So I think that there was a hope that the GDPR could be used as a way to to enforce some data leakage concerns that publishers have, sometimes rightfully. There's probably some technology companies on the fringes that are not doing what they're supposed to in terms of respecting contracts and what they're allowed to do with data from a publisher's site. But as it turns out, there are also a lot of cases where as you say, publishers are trying to use GDPR and consent frameworks as a way to just control who gets access to their signal and who gets access to their data. And I think that conflating the two, although I get the reason why, can result in an implementation that is not actually illegal or doesn't achieve the legal bar that you're trying to hit.
Right. And I think one piece of this that we all have to again remember is this is regulation, right? And it's something, again, Americans are not used to, a little bit more in the EU, that the regulation has been put in place, and it's going to be court cases that are going to sit there and decide and make what is law and so forth. One thing that just came up in the chat, right, is that the Czech market is that the situation is different, where there's an active opt-out regime. Again, that's pretty interesting. That's news to me, right? That different countries, right, are going to look at the regulation and are going to have different interpretations. Do you follow it kind of at that level, or are you following kind of the overall scheme of things? And obviously those country by country things are going to come up as things for us to have to think through.
No, I definitely am watching the country by country reads of the regulation and of the e-privacy directive. And so my familiarity with the Czech market is that there's a movement to treat compliance based on opt-out, and maybe that's what their data protection authority, how they're going to enforce it. However, that is not the GDPR does not give you that leeway, and the e-privacy directive no longer gives you that leeway. So that could wind up being sort of a bellwether case that tells the rest of Europe, no, in the case of the Czech Republic, that's not going to satisfy the law. And then, of course, there are other markets such as Germany that we follow really closely, where Germany's point of view going back many years has been that consent is not required to comply with the e-privacy directive, for reasons I won't bore the audience with right now. But if you're a company, typically you're operating across Europe, so you have to understand all of those nuances. If you're a publisher, you're probably getting traffic across all of Europe, even if your site's dedicated to one specific country. So you should be cognizant of that.
Yeah. One thing that you and I discussed was that some of the solutions that are out there might be creating a little bit of a false sense of security. That their purpose was otherwise, and now they've labeled as GDPR compliance, right, and a consent mechanism. And can you kind of talk and make sure that again, this would be really good practical advice for someone to sit there and perhaps look at whatever solution they've chosen and start to ask some tough questions to make sure that they're on the right platform.
Yeah, I mean, there's a lot of websites that have had solutions in place to comply with the e-privacy directive for years and years, going maybe even back a decade. And those solutions sometimes were either just displayed a cookie banner, or if you are also trying to satisfy opt-out requirements that the EDAA tells companies they need to meet, or in the US, the NAI or the DAA say that they have to meet. That was great, but those solutions are not designed to comply with the GDPR. And I'm still seeing a lot of cases where companies that had previously offered opt-out solutions are now calling them GDPR compliant solutions, And they're definitely not GDPR compliant solutions, since the rules for what you have to do under the GDPR are completely different than what you have to do to comply with the EDAA, the NAI, or the DAA.
And so that's something it might give you really a false sense of security. If anything, it might actually make you, I won't say a target, right? But there may be something where there's a someone looks to make an example to show that it is not compliance, right? That's something?
Yeah, absolutely. I mean, I spent a lot of time talking to data protection authorities in Europe, meeting with them face to face. And this is something that comes up in a lot of the meetings that I have, where they will say, why do you think that all of these opt-out mechanisms that I see still in place are going to comply with the GDPR, when I, as a data protection authority, I'm the data police, I know that they're not. And every time I hear that, I think, boy, so they're gearing up to go after somebody, and I would not want to be in their shoes.
Yeah, yeah. Talk about the idea of passing on a legal signal again. So I think a lot of people have gone kind of that whitelisting. Can you talk a little bit more about what might be kind of required there, or how to think that through?
Yeah, I mean, if you're going to send a legal signal, you first should make sure that it was obtained correctly in the first place. So there should be a UI first that a person who's visiting a website is greeted with, that gives them the opportunity to provide consent to access their device. And there's a standard in the GDPR that everybody now needs to follow. So in the past, you were using a standard that was based on this old law that still exists called the e-privacy directive. Now even the e-privacy directive points to the GDPR on its definition of consent. So you want to make sure that when you're gathering consent, that it is specific and unambiguous. And you need to provide transparency into how who might be processing data and accessing the device. So you need to have a link into companies that might be operating on your website. And then once you collect that information, both consent to access the device and establishing a legal basis to process data. So those are two separate things. The first is to comply with the privacy directive. The second is to comply with the GDPR. And for the GDPR, you don't need consent. You can use another legal basis like legitimate interest. But once you've surfaced that transparency into who is operating on the page, and the user has either provided consent where it's required or has been notified transparently about what's going on, then you should pass the signal along to whoever your partners are. And you should only pass it based on whatever you've collected from the user. Instead, what we're sometimes seeing is users are not being provided with that level of transparency. Companies, publishers are just choosing a whitelist of vendors that they want to work with, and then sending the signals to that whitelisted group of vendors without having surfaced them in any way to the user first. And that's something that probably is not going to comply with the law.
Right. Consent is not ads.txt for the user, right?
It is not.
What I hear is data leakage, ads.txt, and GDPR all being kind of thrown in together. And again, without necessarily respecting kind of what we're trying to do there. You've mentioned e-privacy a couple of times. Sorry, I say it the British way. That's where I pick up e-privacy directive. That's right for its next act, right? I mean, that's I don't know that the timetable is necessarily clear, but I'm hearing 2019. We'll still be talking about GDPR, I'm sure, but we will also be talking about the next level of requirements around e-privacy. Is that correct? Do I have that correct, son?
Yeah, I mean, they drafted a new version of the e-privacy directive. It's going to be an e-privacy regulation this time. The difference is that in Europe, a directive, or at least in the European Union, a directive is a law that's created by Brussels, and then every market needs to enact its own version. A regulation is a law that automatically applies to the entire EU. And so they're turning e-privacy into a regulation. It's still in the process of being negotiated, and I hear various things about where it sits in terms of timeline. But right now, I know it is sitting with the EU Council, and they're finalizing some points that they want to codify to both update the original ePrivacy directive and close the gap in certain areas of the GDPR. For example, it's possible that the ePrivacy regulation could take a stand on what legal basis companies could use to process. So they could say, instead of the 6 that are allowed under the GDPR, they could say that there's only one, or it could say that there's only one under the privacy regulation, which is consent.
Got it. And it's certainly the privacy stuff. It certainly would be, I'll say, good. I'm not sure how it plays out, right? But it'd be good to get a little, again, more meat behind that, as well as this, right? So we all know kind of what to do. I think that's part of the issue here. Why we're all kind of scrambling and trying to find out what's going on is that it really isn't clear how this is going to play out.
Yeah, I mean, I know that's what keeps a lot of companies up at night right now, which is the fact that there is some ambiguity in the GDPR, and they're really not sure. They're not sure what to do. You know, for example, even though the standard for consent, if that's what you're going to use to process data under the GDPR, is unambiguous, it's not clear what unambiguous consent actually means, or what regulators will accept.
So unambiguous is not unambiguous, is what you're saying.
That's exactly right.
Awesome.
And so, practically speaking, what does that mean? That means that consent does not necessarily need to be something where you click a yes button, check a box, or make one of the actions that we might traditionally associate with agreeing to something on the web. Instead, it could just mean that you've been shown a notice when you visit a website that you can't miss, and then you click through it to just get to the actual content of the website that you want to see. That also would be unambiguous consent under the law. So these are all examples of things that companies, I think, are looking for certainty on. Maybe the ePrivacy regulation helps give companies that certainty, so that at least they know where they stand. But I also think it's likely that there will be some cases that travel through the European courts that also provide that certainty.
Got it. You've mentioned privacy policies is something that people should look to update and make sure are in place. Can you share with you your recommendations on that?
Yeah, I mean, the law is very specific about providing transparency and documenting what you do in numerous cases. And so I think in privacy policies, it's in a lot of companies' best interests to explain what legal basis they're relying on to process data. There are 6 listed in the GDPR. The 2 that are probably most relevant to the digital advertising space are consent or legitimate interest. So if you're using one of those to process, you probably want to explain what it is that you're doing and why in your privacy policy. Remember that you also need to provide users with their ability to submit subject rights requests. So, for example, the right to ask for portability of their data, the right to delete their data. There needs to be a mechanism in there for them to communicate with you if you're processing personal data. Providing that functionality and transparency in your privacy policy is something that not everybody has done to date, and it's as long as you're actually taking the steps on the back end, it's a relatively straightforward way to prove that you're making an attempt to comply with the law.
Yeah, I'm thinking through, and I'm going back to the early 2000s when I had to help the legal team for the website I worked for walk through targeting and behavioral targeting and what we were doing with data. And obviously what came out of that was this big blanket statement of, you use the website, we're going to use your data. Because from a legal perspective, that's just much easier to get that kind of just out of the way. And it is really interesting what you're saying, which is not only are we going to use your data and we're going to have this situation, but you have the opportunity to tell us to delete it and so forth. I'm going to be interested. You and I could have this call a year from now, and I'll be curious to how many people move on that front until, again, it's really spelled out. But it is part of it. As long as you're doing the back end, updating a privacy policy should follow, right?
Yeah, I mean, I think, on both sides of the Atlantic, in the United States and also in Europe, what regulators want to see is that you're providing transparency to the user who's coming to visit your site about what it is that you're doing. There's a lot of details involved in what you should be transparent about, but that's really the principle that you should be trying to meet. Not hiding the ball, but telling the user exactly what it is that they're doing. And then the additional step that the GDPR actually codifies in Europe is that you're actually giving the user control over certain rights that are relative to their personal data, so that if they want to take some action and tell you to stop doing something, to erase what it is that you've done, or to show them or what it is that you've processed about them, if you are a data controller, of course, then they have the ability to do so. And what some companies have done, just to take that requirement a step further, is they've built an automated system in their website so that the user just has to, instead of emailing you, they just have to go to your website and with one of their questions, and then they can automatically receive service for whatever their request is, which I think is excellent.
Yeah, interesting. So, and we'll see how that plays out. What other recommendations do you have for people? Again, now that May 25th is passed, it's time to do this right and do it. What are your recommendations?
I mean, the primary thing I think would be to make sure that you have set up, if you have a website, some method for communicating to your users that is updated compared to what you were using before May 25th. So it might be worth considering that the cookie banners that were in place to comply with the e-privacy directive are not what you should still be doing in order to comply with the new requirements under the e-privacy directive and the GDPR. And so ultimately, the two boxes you want to check are have a way to ask for and receive consents to access the device, and a way to communicate how you are going to be processing personal data and how your partners are going to be processing personal data. The second thing, as we just discussed, that I probably want to make sure that I was doing is that my privacy policy is updated to reflect the requirements under the GDPR, so that you are being transparent and communicating to users, ideally in language that they would actually be able to understand, so that they can understand how their data is being processed by you. And then on the back end, I would want to make sure that whoever I'm working with to support my website, whatever technology partners on the supply side or the buy side, are doing the same things. So that if I have a website and I'm the data controller and sharing data back with somebody else, they're not doing something with it that is either illegal or in a gray area that could get me in trouble.
Got it. Last question I'll really have for you, obviously because there is more that's going to develop. Don't even know the timeline, but we all have to kind of track, right? As I said at the beginning, consent and compliance is now really a daily task for companies. What do you read? What are you tracking? Or how are you keeping up to date on all the moving pieces?
Yeah, I mean, I almost hate to admit this, but Reddit is a great source of information if you find the right subreddit on stuff like this, just because you get people's emotional reaction to things, and sometimes that could be interesting. But on a more formal and really well researched and thoughtful point of view, the Future of Privacy Foundation really does an excellent job producing work or sharing specific articles that I find helpful, trying to understand how the law is going to be interpreted. Finding individuals is also good when you wind up trusting them. There's a ton of different points of view out there. So you want to find somebody who actually makes sense. I'm a big fan of Phil Lees, who is a partner at Field Fisher, who is a privacy lawyer, and he blogs a lot. But it's not. I wouldn't say there's anything self-promotional about what he does. It's actually incredibly helpful. So I would recommend reaching out to him. And then this is probably obvious to a lot of folks, but the regulators themselves and the Article 29 Working Group, which is now the European Data Protection Board, produce guidance, which is useful because it tells you how they're planning on interpreting the law. So I'd recommend looking at all the guidance that they've published, which is on their website. Is a great way to figure out, okay, what is it that I'm doing that regulators will actually accept.
Yeah, and to that, when I was at the IAB Europe event, we spoke with one of the regulators, and I'll just say for everyone, he was quite clear that his belief is that ad tech has been collecting information by any means possible to do whatever you want to that's possible. Yep. And so when you think about that, GDPR is bigger than ad tech, right? But we are unfortunately the example that they're going to use of how this is affecting people and so forth. So I think that's something to follow. What I'm gonna say, Ari, is we'll follow up, and I want to get those links from you. And okay, when we publish this out, let's include those links. I think that'd be really, really helpful. I'll just add one that I follow. It's on Facebook because I do follow the Reddit things as well. On Facebook, E.L. Katz has done, I think, a great job of curating great articles and so forth. So look for him on that, and I think that'll be useful to everyone. So Ari, I want to thank you for your time, your insight. Obviously, an ongoing conversation, but I think there are, from my perspective, some key takeaways. Certainly, now that May 25th has passed, it's time to really stop scrambling, start thinking further through what your overall solution is. Look at your solution. It might technically say GDPR compliant, but might not be. Obviously, moving toward a standard is going to have great implications if we can all, again, send the same kind of signals through. Privacy policy should follow what you're doing, and keep track of what's going on. So Ari, thank you for your time.
Thank you. It was a pleasure.